Okay, and I'm seeing people start to filter in. We'll give it just one because we had any number of people. We had many last minute registrations, which I'm especially excited about, but I am going to go ahead and start recording. Okay, and we'll give it just one more minute. And I'm seeing those numbers jump. This is fantastic. Okay. And the number of attendees is holding fairly steady right now, which I think means that we should probably get going. Good afternoon. My name is Victoria Esposito. I'm the Advocacy Director at the Legal Aid Society of Northeastern New York. This is the third in our series of virtual town halls about COVID-19 and various legal areas. As you can imagine, we've had a lot of questions about housing. It's something that people are concerned about at the best of times. And as I think you all know, we're not in the best of times right now. Before I introduce our panelists for today, a couple housekeeping matters. We've read all the questions that people have submitted ahead of time. Thank you so much. We've incorporated as many of them as we can into our presentation. There is a Q&A available at the bottom of your screen, at least that's what I'm seeing, or a chat. You may submit questions there. Please be advised that number one, we may not get to all of them. Number two, most importantly, what we are giving today is legal information, not legal advice. Information is general information that applies to almost anyone's situation. If you want something that's very specific to a particular set of facts, that's legal advice. That's something that none of us is really able to give on the fly like this. However, if you want advice specific to your situation, you may certainly call our COVID-19 number. You can see it on the screen right after my name. That's 1-833-628-0087. And you can use that number from any one of our service areas, any one of the counties we serve. Please call and we'll see if you qualify for our services and how we can best help you. With me today, we have Tara Glynn. Tara, if you'd tell us a little bit about yourself, please.
Hi, everyone. My name is Tara Glynn. I am a senior attorney with the Legal Aid Society of Northeastern New York. I am based out of our Plattsburgh, New York office, where I focus primarily on housing issues and primarily on tenant defense.
Terrific. Thank you so much. And also David Crossman. David?
Hi, everyone. My name is David Crossman. I'm a staff attorney. I practice out of the Albany office, also in housing, primarily representing tenants. My area is generally Schenectady County, so I spend a lot of time in the city of Schenectady.
Thank you so much. And before we really get into this, and as I said, people have had questions about housing, many questions about housing, but I thought it'd be helpful to give just an overview of how the eviction process works in New York, because I think it's going to make the rest of the discussion easier. Tara, if you want to start, and then David can chime in.
Sure. So the basic premise of a landlord-tenant relationship is a tenant is renting a premises from a landlord. When that relationship breaks down, landlords can seek an eviction to have a tenant removed. A tenant cannot be removed. You are not formally evicted until there is a court process and there is a court order requiring that the tenant be removed from the premises, which has to be enforced by local law enforcement. There are, generally speaking, two types of summary proceedings, which is the formal name for an eviction. There are non-payment proceedings and there are holdover proceedings. Non-payment proceedings, as the name would suggest, is when there is an issue surrounding payment for that premises. Most typical is that there's rent that is owed that hasn't been paid. Basically speaking, every other type of eviction would fall under a holdover proceeding. Some way, shape, or form through some sort of notice, which we're going to get into later, is issued that terminates the tenancy. The tenant does not voluntarily leave, so an eviction process is brought to have them removed.
Thank you so much. David, anything you want to add to that or clarify?
Just to add to that, the two different types of proceedings have two different types of notices before you get to court. We call them predicate notices. So they're much different timelines. For a non-payment, you're basically looking at a 14-day, what's called a rent demand pay or quit. On a holdover, you're looking at anything if it's a licensee of 10 days. If it's a tenancy, it's probably going to be 30 days, potentially on up to 90 days. And when you go to court, what you can kind of expect is, especially nowadays, the court, well, I shouldn't say what we can expect now, but what we used to expect was that the parties would talk to each other and see if they could resolve things. But worst case scenario, as Tara said, you can't be evicted without a court order. Worst case scenario, you're going to get at least 14 days notice after your court date on a warrant of eviction.
Thank you so much. And also, before we get into the meat of today's town hall, I just want to touch on the different kinds of courts you both practice in. David, what settings do you practice in? Urban, rural?
I'm primarily in urban, so city of Schenectady is probably about 80% of my time, and I would say about 20% of my time are the towns in Schenectady County.
Excellent. And Tara, let me ask you the same question.
I'm overwhelmingly in rural courts, which are known as town and village courts or justice courts. I cover Hamilton, Franklin, Essex, and Clinton County. The only city court I have is the city of Plattsburgh, so overwhelmingly in justice courts.
And would it be fair to say that the practices differ a little bit at the best of times in city court and justice courts?
I would say that. So the city courts are ruled by the Uniform City Court Act. Most importantly, the judges are required to be lawyers, and the courts also have different types of relief, including, and I think something we'll get into, the ability to issue repair orders. Justice courts, the town justices do not have to be attorneys. Very frequently, the court process is fairly informal to what you would consider. I affectionately tell my clients to expect Judge Judy, not Law and Order.
David, anything you'd like to add to that based on your experience?
I would say sometimes, depending on the justice court, the schedule, because of the scheduling, the schedule might be a little bit longer. Some towns only do landlord-tenant cases once a week, whereas city courts generally are doing them, more often.
Thank you. So now, as far as COVID goes, we've seen some fairly major changes to the housing law for the duration. Tara, I'm going to ask you to give an overview of what we've seen in state law. And then David, if you'd follow up with federal law.
Sure. So in New York State, there has been kind of a patchwork on dealing with the housing crisis caused by COVID-19. The first was Executive Order 202.8, which was issued back in March, which halted all eviction proceedings and enforcements until June 18th, 2020. So importantly, that was any pending proceedings, that was any proceedings that had yet to be filed, that was warrant evictions that had already been issued but not served, warrant evictions that had been served but not enforced, anything. All of it was halted until June 18th, and that still is in effect today. Then on March 23rd, 2020, the Unified Court System issued Administrative Order 7820, which halted all court filings except for what was deemed quote unquote essential matters. And that was until further notice. As of right now, that is also still in effect. However, we do not have a sunset about when that is going to be lifted. Essential matters for housing have not included any type of eviction. They include landlord lockouts, reductions in essential services, serious code violations, repair orders, and post-eviction relief. So these are primarily methods for tenants to get into court, not necessarily landlords to file in court. And then most recently on May 7th, Executive Order 202.28 was issued, which was billed as extending this eviction moratorium from June until August 20th, 2020. That's not necessarily the case. It's very vague, and frankly, housing advocates the state over are kind of debating about what it means. Importantly, it goes from June 20th to August 20th. So there's 2 days, June 18th and June 19th, are unaccounted for. It stops the initiation and enforcement of an eviction for non-payment of rent until August 20th. This is distinctly different than the first eviction moratorium, which banned any and all forms of eviction. This covers residential and commercial evictions. It is limited to someone who is eligible for unemployment insurance or benefits and can demonstrate a financial hardship due to COVID-19. It's unclear how that's going to be established. It's unclear who the burden of that will fall on. So there's still a lot of question marks surrounding a lot of this. However, this latest executive order also stops any fees for late payment of rent for the entirety of March to August, and that seems to be for any and all tenants during this time. It also allows for, at the tenants or licensee's sole discretion, to elect to use their security deposit to pay rent. This is different than how security deposits are normally allowed to work. And if a tenant decides that they want to do that, we strongly recommend you get it in writing. You'll be required to start paying that security deposit back to your landlord within 90 days of you electing to use it, and you'll have to pay it back at 1/12 installments. So ideally, you should be paying it back within 15 months of you electing to use it for your rent.
And just one quick note, is it that we recommend that it's in writing, or that it must be in writing under the executive order, that kind of agreement?
We're recommending that it be in writing. It's not required to be in writing.
Thank you. And we'll unpack a little bit of that a little bit more as we go. That's a lot of information. And as you say, a lot of it we don't really know. David, with respect to the federal laws?
Okay, on the federal end of things, the CARES Act was signed into law in late March. Basically, as far as landlord-tenant cases, this applies to covered dwellings and covered properties. So we could start with the things that we know that it is definitely, that are obvious. It applies to public housing. It applies to Section 8, both vouchers and project-based Section 8. It applies to low-income housing tax credits, USDA rural development, and probably a whole host of supportive housing that is federally subsidized. What is a little less clear, or will be a little bit harder to tell if the property is covered, is it includes single and multifamily properties that have federally backed mortgages. So this includes Fannie Mae and Freddie Mac. As you can imagine, that might be a little hard to distinguish. I think it's easy for a tenant to know that they have a Section 8 voucher. Obviously, they know that. Whether their landlord has a mortgage that has some federal backing, that's less clear. The way I think of it is that, state evictions are a state matter generally. So there has to be some kind of federal hook to get this law to apply. And generally that's going to be this federal funding or backing. I know that at least one state court, not New York, but one state court, Georgia, has actually said that they're not going to accept eviction filings without an affidavit from a landlord saying that the CARES Act does not apply to their property. And when you think about it, practically speaking, the landlord is in the best position to know that information. So we'll see how that plays out in New York once we get back into the courts.
And that raises a question, David, if I may. Let's say that I'm your landlord. I have a Fannie or Freddie mortgage, backed mortgage, and I'm going to evict you. How do you know? Do you have any possible way of knowing that this is an eviction that shouldn't be happening at this time?
There are some new tools that are coming out, some online tools. We're still exploring those. So with that particular piece of information, there's not a real clear way of knowing, as far as I can tell. There's an argument to be made, like I said, that it should be the petitioner, it should be the landlord who says, no, it's not covered by this eviction. So there's at least an argument to be made that the landlord should provide that information to the court before proceeding.
Thank you. So, Tara, I'm going to step back to a couple of the things that you mentioned as essential. And we do have one question which actually fits in very nicely right here. The question is, can the predicate notices still go out under COVID?
Yes, is the easy answer to that. There's no ban of service of the predicate notices. There is an interesting hiccup under the Real Property Action and Proceedings Law, which is the law in New York State that governs how eviction proceedings have to go forward. In that, generally speaking, several different types of notices have to be attempted to be served personally, which I'm not sure how personal service would be done through social distancing requirements. But aside from hiccups like that, which will have to be duked out in court, no, there's no prohibition on service of predicate notices.
Thank you. So, I'm sorry, I'm also checking the chat box as we go. So you mentioned a couple of essential matters, and what you said was that the chief administrative judge specified that no evictions are essential matters that can be filed during the pause, but that something called landlord lockouts is something that you can go to court for. Can you tell us what those are?
Sure. So a landlord lockout is a generalized term for anything that a property owner or landlord does to prohibit access of the occupant to the dwelling, right? So this could be a tenant, a licensee, or any other type of occupant, a guest, anyone like that. And the landlord takes any steps to prohibit them from being able to enter. We've seen this range anywhere from changing the locks, stopping electrical service, stopping heating service. I've seen doors be removed, front doors be removed. I've seen windows be removed. I've seen appliances be removed. One very creative landlord took a Sawzall to the wall and removed a water heater. Anything like that would qualify as a landlord lockout.
So that's something that a tenant can still get into court to fix. And obviously what the person should do is call an attorney, right? But what's the procedure once that's happened, generally speaking?
So that's going to depend county by county. Different areas are open in different ways. I can tell you what it is in the counties that I work in, where all of them have one designated area. Here in Clinton County, that's the Clinton County Courthouse in the city of Plattsburgh. You would file your essential motion there, for a judicial intervention, where you would state what it is that you're seeking, which in the face of a lockout, you'd be seeking some sort of court order to get you back into the property.
Thank you so much. And David, I'm going to take you back to something that Tara said, if you wouldn't mind speaking to this. She also mentioned essential repair orders, serious repair orders, I'm sorry, are still a matter that are considered essential. Have you seen that kind of thing be brought? I mean, obviously, normally you would have code enforcement inspect the property and tell the landlord what has to be done, correct? In your experience, how is that being accomplished right now? And how does that play into repair orders?
Well, currently, I have not personally had to go into court for this, which is, knock on wood. I always think of worst case scenario, so I was expecting to have to go in before now for these things. This is one area where city courts and other courts differ. As Tara alluded to earlier, there is a method for in city courts to ask for an order to make repairs. Of course, you're going to have to call code. That should be your first step. My understanding is, and I can't swear to other areas, but my understanding is at least the city of Schenectady is doing emergency inspections. They're also doing some inspections where DSS is waiting on their inspection to pay the landlord. And that's my understanding in the city of Schenectady. So your first step should be to call code. Obviously, if the landlord is not resolving the issue, I would recommend that you call our office. And I did also want to go back. I wanted to clarify the time frame. Sorry to skip around, but I don't think I mentioned the time frame for the CARES Act that expires at the end of that covers non-payments through July 27th.
Thank you. And tell me what you mean by covers. So could somebody be evicted on July 27th?
They should not be evicted. No, they should not be given they shouldn't really be given a notice. They can't charge late fees for that time period either. So that at the 27th is a Monday, you might see some other dates, but Monday is the first date that they can file a non-payment notice and petition. There's
Thank you
also,
so much.
oh, I'm sorry.
Go
There
ahead.
is also
No.
some discussion about the other type of proceeding, the holdover proceeding. There is a section of the CARES Act that does say a tenant can't be forced to leave without being given 30 days notice, and that 30 days notice to vacate can't be given until after the expiration of that moratorium at the end of July. So in a holdover, the way we read it, the earliest that a tenancy could be terminated would be the end of August.
Thank you. And I'm just going to note we have one comment. And this is from Dave Cagle at Western New York. Hi, Dave. But Dave is telling us that code is considered essential and their code officers are continuing to work in his service area, which I believe is Geneva. So I think the lesson here is call your local code enforcement. It's not one size fits all. Would that be a fair statement?
Absolutely.
I think so. I know in my area that in my areas that code enforcement is essential and they are still going out, but they are certainly prioritizing and taking steps to ensure that their safety and the tenant safety is still through COVID-19 and social distancing measures. So absolutely continue to call, but be aware that they have their own set of priorities that is different from non-COVID-19 times.
Sure. And I have two questions about that go specifically to the CARES Act moratorium. So David, I think these are for you. First, is Shelter Plus Care covered?
I would say yes. There is federal funding. It's a type of voucher, so I would say yes.
And excellent, thank you. So that's the hook again. Any kind of voucher, any kind of federal funding is where you're looking for that.
Correct.
And the second question I'm seeing is there a prohibition on predicate note service for CARES Act covered housing specifically?
That gets a little messier. There are some provisions for forbearance of, I believe it's forbearance for mortgages. So there might be, there's different language used in one section that says initiate or evict, and in another section it just says evict. So as far as non-payment proceedings, generally we're looking at they can potentially serve the predicate notice beforehand. I would say, they might want to wait until they've accumulated all the rent. If you serve a rent demand in May, you might miss June and July.
Excellent, thank you so much. So let me ask you, what are, let's see, this looks really specific, so I'm going to move on with this. But what about, and I'll throw this open to either of you, what options do people have if they, for example, their lease is up, they want to be out of the house they're living in or the apartment they're living in, their landlord wants to maybe show it, and they have concerns about their safety. Is that something that's a legal problem? Is that something that's a social problem? What's the best way to address it in these circumstances?
So just to clarify, this is a situation where the lease is over, the tenants are looking to vacate, they're in agreement with the landlord, they're vacating, but the landlord wants to show the apartment before the tenant leaves?
Correct.
So I would argue it's both a social and a legal problem. So when going back to the fundamental relationship between a landlord and a tenant, you're paying rent to reside in the premises, that you are the legal resident, which means everything that comes along with being a resident of a dwelling, which includes excluding people from the property. That includes the landlord. You do not always have to let the landlord in or let the landlord do what they want to at the property. That's partially what you're paying for. Barring anything that may or may not be in the lease, because again, we're generally speaking here, you would be well within your rights to exclude the landlord especially if you believed your health and safety were at risk. Generally, when you see these type of clauses in leases, there's always a qualifier of reasonable. landlord will give reasonable notice. The landlord's allowed to be on the property when it is reasonable, things like that. If they're, especially if you're talking about people who are immunocompromised or face other health challenges, it would be reasonable to exclude people from the property.
Thank you. David, anything to add to that?
That's pretty comprehensive. I would just say if it does become a dispute where you feel that you're fearing for your safety, the local police would be the place to call first.
Excellent, thank you. And another question here that goes more really to subsidies. So David, I'm going to pitch this to you first, but Tara, please feel free to chime in, okay? What if you get the unemployment assistance, and especially the extra $600 a week in unemployment, but you receive a housing subsidy? Could that affect your housing subsidy?
That's going to be probably a case by case or a fact specific case. We always recommend, that you disclose the money that you're getting into your housing authority. HUD has issued some guidance to public housing authorities that they can waive some certain requirements, recertifications and things like that. But it's up to each public housing authority to elect to do that. So it would be very important for each person to contact the housing authority and find that out.
Thank you. And would it be safe to assume that would be the case for people receiving Section 8 as well? Excuse me, let me back that up. Would it be safe for me to assume that would be equally important for people who are in public housing or receiving a Section 8 voucher?
Yes, that's correct.
Thank you. Tara, would you like to add anything?
No, I would like to echo just what David said, that not only does it vary housing authority to housing authority, depending on what, if any, waivers they've elected to utilize, but it also depends on the type of subsidy. Like you said, public housing is different from Section 8, is different from Section 202, is different from Section 504. So they're all different, and it's hard to give an answer without those specifics.
Thank you. Now, the one thing that I'm realizing we haven't touched on that many people have asked about. We know that nobody can be evicted during the pause during this period. What about rent? Do you still have to pay rent during this time period?
What I've been telling people is that there has been no law passed that cancels out a tenant's contractual obligation to pay rent. There's a lot of calls for it. I was looking today, I think there's no less than 7 bills pending in the state House and Assembly. New York City Council has been looking at things, and I know several county legislatures throughout the state are looking at things, but to date, I have not heard of anything that officially cancels a tenant's obligation to pay.
David?
That's correct. I don't have anything to add except to mention, I believe that late fees from March 20th through August 20th are not allowed to be charged at this point.
Thank you. So what happens? Let us say that someone unfortunately loses his or her job and is unable to pay the rent. Can they be then evicted come July or August based on the non-payment?
In theory, there's a lot that will go into that. Why could they not pay? Were they COVID affected? What, if any, other types of services are out there? Local counties are having access to CDBG grants. DSS can help people who qualify for their services. So there is a lot that goes into that, but theoretically, yes. If you owe the rent when the court's open, you could be evicted for non-payment.
David?
Yes, I agreed in theory. The other thing to keep in mind, practically speaking, though, is there's a line of eviction proceedings that are backing up right now. So it's practically speaking, we don't know what summary proceedings are going to look like in the near future when they get going again, but I think we can all agree that there are going to be a lot of them.
Thank you. And let me ask you about, that raises another question, David. If we know that there were some people who had actually gone through the court process and had had a warrant of eviction issued against them before the court paused. And I believe you and Tara said earlier that those cannot be executed. You just cannot be evicted right now. What do we know yet? What's going to happen with those particular cases?
We do not know at the moment. I know that there are calls for warrants of eviction to be reissued or at least reserved so that that 14 days that we mentioned earlier would restart. I think, again, practically speaking, that's probably what's going to be the most efficient, probably even for those sheriffs and marshals who are executing the warrants.
Thank you. Tara, anything to add to that?
No, I agree with David. At this point, we really don't have clarity, and the local law enforcement that I've talked to also does not have any clarity on what's going to happen.
Thank you. So another question that has come up, and we're dealing with all of this in the context of a pretty major overhaul of the landlord-tenant laws last June, correct? So we're dealing with new laws in a new situation, I guess, for lack of a better phrase. There's a thing, as I understand it, called the hardship stay under the new laws, which applies to the whole state. Can you guys tell us a little bit about that and why that might be key in the wake of the pandemic?
Sure. So the hardship stay is under the Real Property Actions and Proceedings Law, as I cited before. Generally speaking, it is a mechanism the court has to either stay the warrant eviction for a period of more than 14 days. As we said, part of actually one of those changes was to change the warrant eviction from 72 hours to 14 days. But through the hardship stay, the court can stay the warrant eviction for up to a year, 12 months. It also appears to be a mechanism where the court could intervene to give the tenant more time to pay the rent, to stop a non-payment proceeding, such as, like I said before, utilizing some of those funds that might be available to them to make up for the difference. These type of hardship stays or any of these type of stays, either under 749 or 753, are incredibly fact specific. So we can't say, if you did X, Y, and Z, you'll get a hardship stay. It really just depends.
Thank you. And that's a very lawyerly answer, of course. David, anything to add to that?
Just no, I mean, that's exactly right. And and the same factors for one court might not be as persuasive for another court. And the other thing, looking forward, I think of this as there are a lot of factors that go into it. And some of them are factors for the landlord themselves as well, right? Like a hardship on the landlord as well. So it might be more of a balancing act that the courts have to play.
Thank you. And David, I'm going to stick with you. We've had a question. If the landlord's not getting paid rent, can they take the security deposit? This is something that Tara sort of alluded to. She did allude to, she didn't sort of allude to it, but I'd like to draw that out a little bit more, especially in the wake of the new executive order. Can you tell us a little bit about the procedure that's outlined in last week's executive order for using the security deposit as rent?
Sure. My understanding is that's pretty much at the sole discretion of the tenant. I believe there is a section in there that says that a landlord shall not harass a tenant into entering one of these types of agreements. So it's up to the tenant, and the tenant should reach out to the landlord. And it's probably not a bad idea to call us first if you want to talk it through. We can definitely do that. So again, it's at the tenant's discretion, not the landlord's discretion.
Thank you. And it's paid back over time?
That's right.
Terrific. Thank you. Let me ask you this, and you may have mentioned this a couple minutes ago, but I think this bears repeating. What about, so what are best practices if someone simply is unable to pay the rent under these, in the times we're living in? What would you recommend generally?
So first and foremost is, as David alluded to with the security deposit, is talk to your landlord. The two of you are really in this situation together, trying to figure this out. And New York is a freedom to contract state. So generally speaking, whatever agreement the two of you work out that works for the two of you, as long as it's not illegal or against public policy, will be upheld. This is why I go back to our initial statement with the security deposit agreement. Always make sure you get it in writing, whatever you agree to. And crucially, any agreement that you might enter into with your landlord, make sure that it's an agreement you can actually uphold. One of the nice things about this eviction moratorium, especially the first one until June 18th, is covers everybody. You cannot be evicted before June 18th. So take that time and make sure you really understand to the best of your ability what your future would entail and what you can agree to. And as always, you can contact us so that we can go through more fact specific, possibly even help you draft such an agreement to make sure that it fully protects you.
Thank you. David, what else might you tell a client, generally speaking?
I would probably also tell a client that you can use this time to explore resources, whether it's calling DSS, exploring unemployment insurance benefits if you haven't already, contact some of your local resources for potential help with rent. There are a lot of them out there. You can use this time to see if they're available. You might have to be very patient. I know that a lot of like UIB, Department of Labor, and I know that probably DSS are flooded with phone calls. So it might take a little bit of patience, but we do have some time at least, or more time than we usually have at this point.
And so David, that brings us to another important point. Is DSS still open and offering services and rental assistance?
That is my understanding. Yes, they are open. I believe they're also required to be open for in person, but they are waiving some of the requirements. So there can be more stuff done over the phone than usual.
Great. And so is that uniform across departments of social services, or does it change depending on where you're at?
It should be uniform, is my understanding, across the state.
However, there's general guidance, but also there's a little bit of wiggle room. So it's probably not the worst idea to,
as always, call first. Yes.
Mm-hmm. And yeah, sorry, the state's issued general guidance, and there's a lot of room for interpretation, shall we say, on the part of the local social services department. Let's see. So another question that's come up, and I'll throw this open to both of you since I know you both deal with this regularly. What if your landlord will not repair a serious issue? And it doesn't sound like we're talking about, a little something broken. It sounds like we're talking about a ceiling that could come down, or, windows that are open that are broken on the ground floor, that nature of thing. What if your landlord will not fix those during this time? What options are there?
So there's several options. First and foremost is to contact your local code enforcement. As we stated, they're an essential service, and especially if you're facing such a significant threat to your health and safety, code enforcement should take that quite seriously and will hopefully come out and issue some sort of order to your landlord to help try to require them to fix it. If you can't get any relief through your local code enforcement office and you can't get any relief through your landlord, you then have the option of filing in court. Like we said before, that is still an essential matter in New York State. You could try to get a court order. If you have access to a city court, like the city of Schenectady or the city of Plattsburgh, you can get it through the city court. If not, generally speaking, what I have to do is go through the local Supreme Court, which there's one in every county, and they can also issue repair orders. It's highly recommended that any attempt to contact your landlord or the code enforcement office, that you keep a record of it somehow, because if you do end up in court, you're going to want to be able to demonstrate that you put everyone on notice of this problem.
And David, what would you add to that?
Not much. I would also add, in addition to documenting contact with different parties, take pictures so you can document the conditions themselves.
Thank you.
Victoria, if I may, sorry.
Please.
David just brought up an excellent point of taking pictures. So this is also something, I'm advising people that if you see a problem in your apartment or your residence that is not yet serious, still report it, still document it, still take pictures, and especially take pictures if it is getting worse over time.
Thank you. And would you send those to the landlord? Would you advise sending those to code enforcement? Both?
Yes, I would send it to both. And I would make sure you get in a form that you can print the pictures so you can send them to court if necessary.
Great, thank you. And a couple people have asked this, so I think this bears repeating. Does the moratorium cover evictions for non-payment of rent or for breaking lease terms as well?
So the initial moratorium until June 18th, 2020 in New York State covers everything. After that, the latest moratorium from June 20th until August 20th is only for non-payment, it states only for people who qualify for unemployment insurance or benefits and can show a financial hardship due to COVID-19. How you establish you meet all of those benchmarks is yet to be determined.
David, anything to add to that?
Just under the CARES Act moratorium, as we've said, the non-payments cannot be filed until the 27th, and any other type of, if it's covered under the CARES Act, should not be brought to court until after the end of August.
Excellent. And that's a perfect segue because we've had a request to repeat, David, what you said about the Section 8 under the CARES Act. If you could just revisit that briefly.
Sure. As far as the moratorium.
Correct.
Okay. So if it's covered under the CARES Act, and Section 8 definitely applies here, that would be covered, Section 8 dwelling, there's a moratorium on filing non-payment evictions, and that is until July 27th. You might see some different dates, but July 27th is a Monday. It technically expires over the weekend, but you can't file those on the weekend. So that's the main thing as far as non-payments. As far as anything else, a landlord cannot require a tenant to leave without giving them 30 days notice after that moratorium expires. So 30 days after July 27th. Now in New York, you're required to give 1 month notice. So effectively that means that any other notice to vacate should not take effect until, as we've said, the end of August. Depending on the length of your tenancy, it might be longer than that.
That's the minimum. Would that be a fair statement?
Correct. That's fair.
Thank you. So one other question that has just come up. If a landlord doesn't issue an eviction notice, given the circumstances, will a tenant still be able to get rental assistance from DSS?
If I may, that I think is going to wildly depend on the DSS. That is something that I have experienced. It varies county by county. So if you are a tenant who has facing rental arrears that you just know that you haven't paid, so you know that you're in rental arrears, I would contact DSS and see what they would require you to establish to get their assistance and go from there. And again, that's something that you can contact our office about. Not only, we do things beside just housing, which includes also public benefits, negotiating with DSS, helping tenants or non-tenants navigate that process.
Thank you. And I'm sorry, I had this 1 second ago. David, this is for you, or Tara, but I'm going to throw this to you first, David. The question is, my landlord has asked me to take out a loan to pay my rent. Is this legal?
Well, they can ask. They can't require you to do so. That's kind of the short answer. There's nothing preventing a landlord from asking someone to take out a loan, but obviously don't do anything you're uncomfortable doing.
And in the same vein, we've heard reports of landlords using, as many people have heard, the IRS has a lookup tool to figure out the status of your economic impact payment, which is what's commonly called the stimulus payment. And we've actually heard reports of landlords calling the tenants and saying, so I know you got your money, so you need to pay me the rent. What would you say to that?
I would highly recommend any tenant facing that situation to contact legal aid or a lawyer in their area. There's a lot of problems with that. Without being more fact specific, I'm hesitant to necessarily say it's outright illegal, but there is, if anyone who's gone to this website, it does very specifically say, this gigantic warning before you put the social security number in, the specified reasons to do so, and checking to see if your tenant got their payment is not one of those specified reasons.
Thank you. David, is this something that you've heard about or seen?
Not personally. I haven't had clients that this has occurred with, but yes, I've seen the news reports, and I was on the website earlier today and copied down the exact word. Unauthorized use of the system is prohibited and subject to criminal and civil penalties. Just to put that out there.
Excellent. And of course, we don't deal with criminal penalties, and the civil penalties might be slightly different, but that is the exact language, right?
That is.
Let's see. And I'm sifting through questions here. What about what should someone do if they're concerned about becoming homeless due to the moratorium? And I guess this isn't so much a what should someone, or excuse me, let me try that again. What would you say to someone who's concerned about becoming homeless due to the pandemic, not the moratorium? What would you tell that person?
I guess I would need to know more reasons about why they're fearing being homeless. If they're fearful that they're going to be evicted and they won't be able to come up with the rent that they owe or won't qualify, for the second moratorium here in New York, that would be one set of answers. And part of which would be legal aid might be able to help them navigate those services to get them that funding. If it's because their housing is unsafe and they need to leave and they don't know where they can go, that's another reason I would highly recommend they contact us. Our housing attorneys are very plugged into the various different types of emergency housing available in all 16 counties that we cover. I'm not off the top of my head coming up with a third reason as to why they would fear homelessness, but housing is a wild, crazy place. So I would recommend they contact us, and we're pretty creative people, and we'll try to solve the solution.
Thanks. David, what would you want to add? And that's a very broad question. I'm aware of that. But is there anything else that comes to mind that you might advise a person other than call us?
Not a lot, just what we've said before. You can also call for resources, call DSS. And again, keep in mind that in New York State, you're not going to be evicted until June 18th at the very, very earliest for anyone, basically. So you have that time to take advantage of and call resources, call legal aid, and try to get everything worked out. And like I said, that's a lot more time than we usually get.
So we've got about just over 10 minutes here. What are a couple things that you think people are maybe confused about, or that you think people might need to hear a little bit more detail on? Or what kinds of queries have you been hearing? What kinds of confusion have you been hearing out in the world?
We've covered a lot of them here today. The number one issue that I've been hearing is, do I have to pay my rent? Which we have covered. One aspect of that I would like to touch on is there's a lot of calls, both state and nationwide, for a rent strike and for rent forgiveness. As we've stated before, to date, there is no law that I'm aware of that forgives a tenant's obligation to pay rent. That being said, should a tenant decide that they want to organize with other tenants or join a tenants association or partake in a rent strike, those are protected actions under the Real Properties Law and Real Property Action and Proceedings Law in New York, and merely participating in those actions cannot be grounds for an eviction in New York State. It would be deemed retaliatory, and there not only is that a defense in an eviction proceeding, but there are also potential penalties that come along with that.
Anything come to mind that you've heard confusion about or upset about in particular?
I think one thing we haven't touched on that I've heard from a fair amount of people is having trouble, they've either negotiated a previous move out date and they're unable to do that. There are a lot of landlords who are reluctant to show apartments right now. My understanding is there's not a lot of movement on the market. I would recommend, if you're having those difficulties, document all of those. We mentioned previously that there's a hardship exception. And if you document those, that will go it will go towards that hardship exception. So, document what landlords you've contacted, how many times you've contacted them, and whether they won't show it or not. And obviously be safe when you're looking at places too.
If I may, to go off of something that David just said about documentation, during this time, I would, as we've been saying through this whole thing, I would document everything. especially for the second half of this moratorium, as I've been saying, a qualification is going to be experience financial hardship due to COVID-19. If you are keeping track of where your money is going, what you have spent it on, COVID-19 related issues, that's going to go a long way to also showing both in the courts and also potentially with other agencies why you're in the financial hardships that you're in. So just document everything.
And would that be a good strategy if you're reaching out to agencies for assistance as well, DSS, the Department of Labor, those places?
Absolutely. A lot of these places, one of the first questions they are going to ask is what happened with the stimulus payment. Not from a judgmental perspective, that's just for their grant reporting and laws that they operate under, they have to document where the money went. So all of those processes are going to go much faster if you already have it documented where everything went.
Thanks. So we have just a few more minutes. David, I'm going to turn to you first. What if you hope people only walk away from this with 1 or 2 pieces of information? What do you want those to be?
I would say that you want to take advantage of the time that we do have, reach out to find out if you're eligible for resources, but also talk to the landlord. It might be that you're both you have a common goal here of getting the landlord paid. If you're talking to DSS, see if you can work something out. And that leads into the second thing I would say is call us. We're here to help. I've been with this organization for quite a while, or a few years at least. And to a person, I've not met a person who works here because it's just a job. We work here because we want to help. And we want to help people who are potentially the most vulnerable people. So we're not just here to help, we're here because we want to help.
Thank you. And I'm sorry, David, I would love to leave you with that. And you have just raised something that I meant to ask about and I completely forgot. I am so sorry. As we've seen in the news, people are relying on public benefits, unemployment benefits, perhaps public assistance, in ways they have never had to before in many cases. What happens if a landlord says, well, I don't want to take, I don't accept public assistance, or I don't accept unemployment benefits as rent? Is that okay?
That is not okay. April 12th of 2019, there was a law passed in New York State that prevents a landlord from discriminating based on lawful source of income. 2 of the main ones that are listed there, but it's not all inclusive, but Section 8 and public benefits are 2 of the main ones that are listed there. That means that a landlord cannot refuse to rent to someone because of that and cannot withhold services because of that lawful source of income. So if you run into that situation, call us. It's worth a call.
Thank you. And again, I apologize. What you said was so beautiful when you wrapped up. I realized we really did want to cover that as well.
More important to get the information out.
Thank you. Tara, is there anything you want to add on to the question of lawful source of income, or anything else that we've talked about before you give your final thoughts?
No, lawful source of income, it's definitely still an issue. And it's something that not even all, I've experienced, not even all landlords are aware that they can't do this anymore. There's a lot of landlords who don't have legal counsel, who aren't plugged into these changes, and these changes are significant. The change not only for source of income, which was April 2019, but as we keep alluding to, this massive overhaul that happened in June of 2019, which, I did a 6-hour presentation on those changes alone. So they're extensive. So, as we've been saying, talk to your landlord and contact us. And sometimes we can just negotiate things with landlords, because some of it just comes from ignorance, not malice.
Thank you. So having said that, what are the 1 or 2 thoughts that you would really like people to walk away with? What if people remember absolutely nothing else we've talked about in this hour, what do you want them to leave with?
I've said it several times, but I'll say it again, is please, please, please document everything. Write it down, keep a spreadsheet, take pictures, text messages, emails, whatever system works for you, notebooks, whatever system works for you. But please document everything. Lawyers love paper. You're not going to intimidate us if you bring us a lot of stuff. And with that is then just to second what David said, which is to call us. Not only are we the legal experts about the issues and for representation potentially in a court proceeding that may follow, but we do care. We are plugged into our various communities. For example, just up in my area, I'm connected to virtually every social work agency, every housing agency, mental health agencies, all of them that work up here, and we all try to do our best to work in tandem. So sometimes a call to us is just the first step to a referral somewhere else. And I'd much rather you get that advice from us than from, people online or people who who are trying to give you good advice but aren't up to date on what the changes are.
Thank you. I believe we've answered all the questions we have out there. There's a couple that are extremely specific, and for those that deal with a very specific situation that look like it deals with your situation, I'm going to say, rather than trying to answer it here, I'm going to encourage people to call our COVID legal line, which is on the screen here. That's 1-833-628-0087. And that covers all 16 of our counties. So once you call that main number, you will get routed to the appropriate office to help you out. And as a matter of fact, Tara, you for sure spend a little bit of time on the COVID legal line now and again, right? David, are you doing that? Or?
Yes.
Yep. Yeah, we both served on it. And yeah, I'd love that we're extending it to past 5, at least 2 nights a week. And it's something that is always manned during the rest of our hours, 9 to 5.
Terrific. Thank you both so much for being here. I know it's a couple minutes early, but I think we've given people a lot to think about. We had 101 people at the height, so I'm really thrilled. And theoretically, we're going out on Facebook Live, so we may well be reaching more people as well. If you commented on Facebook Live, I did not see your comment. I apologize, I'm not tracking those. But you can certainly check our website for information. That's www.lasny.org. Or again, if you're following along on Facebook and you have a question about your situation, you can call 833-628-0087. David Crossman, Tara Glynn, thank you both so much for being here this afternoon.
Thank you.
Thank you. My pleasure.
Thanks to our attendees. Bye-bye.